Are we? Okay. This is a special meeting on January 8th, 2026 of the Nantucket Board of Health. It is being recorded visually and audio. And I can see that right in this room, we have a quorum. It is also a hybrid meeting, so it is on Zoom for those who would like to be, as well as those who are present. It is a training for the board and staff by MAHB, which stands for Massachusetts Association of Health Boards. They have all 351 boards of health in the Commonwealth under their jurisdiction, and we're very lucky to have them today to present to us some things that we all will need to know. I just want to tell everybody here, including the public who may be here in person or online, that this is purely a training meeting. It is not, no business will be transacted, no votes will be taken, no topics other than this training will be discussed. So just so that we're all clear on that. Okay. I think we can get started then.
Good afternoon, everyone. Is someone going to put the slides up?
I've got you ready to share, or I can pop that up if you'd like.
If you could do that, that would be great.
Give me one moment.
Sure. And while you're doing that, I can just introduce myself. I am Cheryl Sabara. I am the Executive Director and Senior Staff Attorney for the Massachusetts Association of Health Boards. We are a membership association comprised of all of the boards of health in Massachusetts. We provide technical education and technical assistance and legal education to the 351 local boards of health in Massachusetts. I have been with MAHB for, let's see, more than 25 years now. I've been in public health law for more than 30 years. So I will just start with my presentation. We always start with a disclaimer. We can provide you with legal education, but not with legal advice. Legal advice comes from your municipal attorney. We do not enter into attorney-client relationships. So a little bit about public health in general. I'm not sure if you can, do you want me to try to share my slides?
I've got it up. I've got two slideshows here. I've got OML, PR Safi, and Legal
That's the
Authority.
second one.
The Legal Authority one?
That's the first one, yes.
Okay. So I will open up the Legal Authority.
Okay, and just go to the third slide would be great.
Gotcha. Theoretically. Okay, there we go.
I don't need to see it. I have my own slides if that works best. There you go.
Is that being seen by everyone?
No, Jericho, you can't see it remotely.
That's what I figured.
You have to screen share screen two.
Health. We just confirmed that.
Now I see it.
And now everyone else should be.
Okay, there you go.
Perfect. Okay. So when we're talking about public health law and the legal authority to address public health law, we need to look at federal law, state law, and local law. And when it comes to public health, federal law really just sets minimum standards. They've really left or they've delegated the legal authority to enact public health laws to the states. And when you're talking about public health law, you're really talking about the law to protect the health, safety, and welfare of the residents of either the state or the locality. So the protection of public health is contained within the police power of a state or a municipality. And in Massachusetts, what our legislature has done is really delegated to boards of health the authority to make reasonable health regulations. In fact, the legislature actually created local boards of health through Chapter 111. So, and the other thing to remember, and this is sometimes sometimes this really does create some issues, is that it is a widely accepted function of all governments to protect public health. And sometimes that can be at the expense of either an individual's privacy rights or freedom and a business's right to engage in business. And case law has clarified this time and time again throughout decades and decades and decades, that we really need to employ a balancing test when we're looking at protecting public health. It can be at the expense of an individual's freedom, and it can interfere with the right to engage in business, because what the courts have said is that there is a paramount right of government to protect public health, even at the expense of the right to engage in business. Next slide, please. And this is especially true in Massachusetts. May I have the next slide, please? In Massachusetts, our Supreme Judicial Court, which is the highest court in Massachusetts, laws that are upheld or made by the SJC can't go anywhere else for review. This is the highest court in our land. And when the SJC has looked at public health cases, they have determined and held that a Board of Health regulation stands on the same footing as a state statute, a local ordinance, or a local bylaw, or a state regulation, and that all rational presumptions are going to be made in favor of the validity of that local regulation that a Board of Health may have enacted. And a court is only going to strike down a Board of Health regulation when someone can prove the absence of any conceivable ground upon which that regulation could be upheld. So the court is not going to substitute its judgment for the judgment of the Board of Health. And I won't go through, there's a really interesting case in Cambridge, but for the benefit of time, I'm not going to go through what that case actually said, but suffice it to say that the court will not substitute its judgment for the judgment of the Board of Health, even if the court doesn't agree with it, as long as the judgment was made pursuant to the administrative record, that it was a reasonable judgment that the Board of Health made. Next slide. And this is important because when the court looks at what the standards are when reviewing a decision of a Board of Health, they're not going to weigh the evidence. they're not going to substitute their judgment. They're only going to overturn something if it was clearly arbitrary or capricious. They're not authorized to do anything other than that. Next slide. And this holds true in lots of different cases. And this is a case from not too terribly long ago, from 2018. And it was a case that was filed by Cumberland Farms against the Yarmouth Board of Health. And the Yarmouth Board of Health, excuse me, fined Cumberland Farms for selling a tobacco product that was a flavored tobacco product. Although it wasn't labeled a flavored tobacco product, it was labeled Jazz. So what the court did was, what the health inspector did was, he conducted a smell test and determined that this product, while it didn't say it was flavored, was in fact flavored. Cumberland Farms appealed the decision and ultimately lost the decision. But I want to look at what the Board of Health actually looked at in determining whether or not this was a flavored product. Next slide. So they looked at some evidence that included, a Google search, a search of how the product was advertised, and the product was advertised as a new flavor, that Jazz had its own unique sweet flavor compared to mild summer blend. Next slide, please. So what the court said in upholding the Yarmouth Board of Health's decision is that what the regulation says is that, does the product have a characterizing flavor other than the flavor or taste of tobacco? And the court said that you don't need to be a rocket scientist to determine whether a tobacco product has a flavor other than tobacco. And they went further and said that boards of health and their agents use smell all the time in determining whether something violates the food code or violates the pool code, or we use our we use our nose to determine whether milk is spoiled or whether there's mold on a pool flotation device. That, these are the things that boards of health do on a consistent basis. This I just threw in because I don't know does anyone remember? Oh, next slide. I'm sorry, you can't see that. Next slide.
Gaia?
Does anyone remember this demonstration here? Does anyone? I'll just tell you. This was the tobacco industries testifying under oath before Congress that nicotine was not addictive. Next slide. Just thought I'd throw in a. Next slide. And you will see that a lot of the cases that actually go up to the Supreme Judicial Court in Massachusetts are cases surrounding tobacco. And there's a reason, it's expensive to get all the way up to the Supreme Judicial Court. You have to go through a Board of Health hearing, then you have to appeal that to the Superior Court, and then you have to appeal the decision to the Appeals Court, and then you finally get up to the SJC. So this is one of the industries that has the resources in order to do that. So a lot of our public health law, case law, comes from these cases. I'm not just doing it for the heck of it, but a lot of them do come from tobacco litigation. So this case is an important case because what this case did was really give us a definition of public health that is really important and that has been used in other states as well. This was a case where The Athol Board of Health prohibited smoking in private clubs. The reason they did that is because the private clubs were acting like public bars, and they were letting anyone in. So they ended up prohibiting smoking in private clubs. And what the court said in this case is that public health isn't about geography. The fact that this was an, in quotes, private club really didn't matter. This private club was still regulated from door to dumpster. It said that public health is about protecting the health of every member of the community, and it's an example where we do regulate private behavior at times. You know, we require smoke detectors, we require helmets at times, we ban lead paint. So we do regulate, and that's where the balancing test comes in. We regulate private behavior and businesses if we feel that the public health needs surpass the privacy or the business interests. Next slide. So, you know, I've said a lot here, and you know, it would give you the impression that boards have this absolute plenary authority. But there are some limitations and some considerations that you want to think about when you're looking at either passing a regulation or performing some other action. And the first one is you want to make sure that there isn't a state law or a federal law that would prevent you from acting. There are some laws that have preemption in that, which means you were prevented from acting. And then you also want to do a risk assessment. What is the risk of harm? Is there a risk of harm? Is the risk to those folks that are unable to protect themselves or that are more susceptible to harm? So we frequently regulate to protect youth, to protect elderly, to protect those with special needs, to protect those that aren't able to protect themselves and that need some protection that they cannot provide themselves. Or is this something that is just caused by one person against another? We run into that a lot where, you know, the Board of Health has looked at a place where someone can go that's maybe having a problem with their neighbor. And does this rise to the level of a public health issue, or is this really a private cause of action between two neighbors? Next slide. And there are some factors in determining that. There are, well, here's my favorite quote. Just because you can doesn't mean you should. And that's where we're going to go. I already actually started talking about that when I talked about the balancing test and so forth. But here are some other factors that you want to consider. When we talked about limitations and considerations, that slide should have been before that, but that's my fault. So next slide, please. So what are some of the factors that you want to consider? And again, we go back to that balancing test. What is the burden to a person? Is this fair? And is this actually going to be effective? We had a case in Brookline decades ago where the Brookline Board of Health wanted to pass a Board of Health regulation that would prohibit the use of cell phones in cars. Now, is that a public health issue? Yeah, it's dangerous to be on a phone when you're driving. I would submit that it's a public health issue. But was a Board of Health regulation going to be effective in prohibiting the use of cell phones in cars? No. I mean, how was a Board of Health going to enforce that? Do they have health inspectors that drive around with cars with sirens on them? How were they gonna do their inspections? Were they gonna stand out at every red light and see if someone was talking on the phone? It was not going to be an effective strategy because they really had no way to enforce it. So what happened years later, of course, is that the legislature passed a law and the police were put in charge of enforcing it secondarily, which made a heck of a lot more sense. Next slide. So we're going to talk now about the delegation of authority, and I described earlier that the state legislature delegated a lot of its police power to protect public health to local boards of health. And it's done it in varying ways. In some areas, like with the state sanitary code, there's a sharing of authority. The state has the legal authority to enforce it, but the primary enforcing agent is the local board of health. And in Massachusetts, there is generally no issue with preemption. Local boards of health can strengthen state laws. They can't weaken them, but they can strengthen them, and strengthening them is seen by the SJC as really just effectively making them stronger, which is consistent. It does not conflict with state law. And next slide. And I talked about Chapter 111, Section 31, and that is the primary authority that gives boards of health the right to pass local public health laws. But there are other specific sections in Chapter 111 that give boards of health additional specific authority. And we're not going to talk about all of them, but we're going to talk about a couple of them. Next slide. First, we're going to talk about the nuisance law. And this is a law that gives boards of health very, very broad authority and very, very broad obligations, because it actually states that boards shall examine into all nuisances, sources of filth, and causes of sickness, which may, in its opinion, be harmful to public health. And when I was in law school, we had a text that we studied, and Professor Prosser wrote right in that text that there is perhaps no more impenetrable jungle in the entire law than that which surrounds the word nuisance. Next slide. So here you are, members of the Board of Health, getting paid the big bucks to determine whether something is a nuisance. And if you determine that it is a nuisance, and again, this is your opinion, if you determine it is a nuisance, then you are charged with getting rid of it, making regulations about it. And there are some exemptions, and the most important one is generally accepted farming procedures. We're not saying best practices. We're saying generally accepted farming procedures. So we're going to just look at that for a minute on the next couple of slides. And again, we'll go quickly through these slides. Next slide. Okay, so as I said, generally accepted farming procedures are exempt. So here, does this look like a free-range piggery? To me, it does. It's a free-range piggery. If somebody wants to eat a BLT, somebody somewhere is going to have to smell a pig. It's that simple. Next slide. Another example of a free-range piggery. Next slide. Is this a free-range piggery? This is a place out in Deerfield, Massachusetts. We were told by the owners of this property that it was a piggery. It was a free-range piggery. Next slide. And another picture of this property. Well, this property was not a free-range piggery. It was actually a dump that pigs lived in. There were doors abandoned doors to Boston cabs. There was a bus that had a tree growing out of the middle of it. It had been around forever. So while generally accepted farming procedures are exempt, circumstances like this would not be exempt. This would be a nuisance. This would be a nuisance, and it would also most likely be a noisome trade. And that's what the court found. We were in litigation for years over this place. Next slide. So how do you determine as a Board of Health member whether something is in fact a public health nuisance? There are some criteria that you can look to in making that determination. And again, it's in the board's opinion what may may be dangerous to public health and a nuisance. But you can base this on public health principles. So again, you're going to go back to that. Is this contained to one individual? Could this, even though it's a condition contained to one individual, could this spread to neighboring individuals or households? Could the individual spread this to a community? Is there a real or a potential health risk? Next slide. Could this condition cause a communicable disease to be spread? Could it cause trauma or injury to the public? Could it cause exposure to hazardous substances? These are some of the factors that you can consider in determining whether something is a public health nuisance. Next slide, please. So if you do determine that something is a public health nuisance, then you would issue a cease and desist order, demanding that the individual abate the nuisance within 24 hours or within a reasonable time, letting them know that they're subject to a fine per day for violating the order. And you would ask them to come before the board to present a plan as to how they're going to abate this nuisance. If the owner doesn't abate the nuisance, the municipality can do it at the expense of the owner and put a lien on the property. And I should say here, while you are subject to a $1,000 fine per day, when we do enforcement in public health law, we want compliance. We don't want to punish someone. We just want them to come into compliance. If you can call them up and say, your dumpster's full, could you empty it? And they empty it. That's terrific. That's what we want. We don't want to be fining someone $1,000 a day for not abating a nuisance. Next slide. The other section that we're going to talk about for a minute is noisome trades, because this is also a difficult one for boards of health because there is so much discretion involved in it. And it's also the type of law which looks to whether this business could hurt the property of the neighbors, which is very unique in public health law. And the kinds of examples, next slide, please. The type of issues that come before the board usually result from or can result from fat rendering plants, auto body shops, asphalt plants. We see a lot of asphalt plants that come before boards. And the Board of Health does have options here. They can actually prohibit a business from coming to a municipality, but once a business is in the municipality, it's sort of hard politically to get rid of it. But what they could do is assign a site. You clearly need to consult municipal attorneys because there may be some zoning issues. And you could assign conditions, like you could limit the hours of operation to 7 to 5, or 7 a.m. to 5 p.m. or whatever. There are ways that you can look at how you would do that. Next slide, please. We're getting close to the end, I promise. Here is just an example of a very recent case where the board made a decision that this asphalt plant was a nuisance and ordered that the plant stop operations that caused odors and fumes to go beyond the boundary of the plant. The plant owner appealed, and it went up to the appeals court, and the court claimed that they would not substitute their judgment for the judgment of the Board of Health. There was plenty of evidence on the record that this was a public health nuisance, and the board's decision was upheld. Next slide. So that's just so you can see this. This is a manual of laws and regulations relating to boards of health that MAHB updated in 2016. It needs desperately to be updated again. Next slide. But you will see, that had lots of chapters, lots of pages, lots of subjects that boards of health are legally required and that are exclusively within the jurisdiction of boards of health. And here are just some of them. And you will see, it's pretty content rich. Next slide, please. And it's easier to look at it probably this way. These are some of the issues and statutes and regulations that boards of health are charged with enforcing. And this is not all of them. Since this manual was put together, we have more tobacco regulations, we have some cannabis regulations, we have some other regulations that come into play here. But this is the knowledge base is really great. And boards of health, either run for office or get appointed, sometimes based on their knowledge, sometimes based on, issues that are very important to them. They may run on a specific issue, which is perfectly appropriate. And, they bring that level of expertise and compassion to the table, but they're not going to be content experts on all of this. It's just impossible. Next slide. So we're going to switch, not very gracefully, into what staff does in boards of health. And they're the ones normally in this neck of the woods that would do inspections. In the western part of the state, we have Board of Health members doing inspections. But luckily in Nantucket, you have staff that's able to do these. And again, the goal is compliance. It's not punishment. We want to get to compliance. You're going to be doing either periodic or complaint-driven inspections. Next slide. And what are some of the issues that come up when you're doing inspections? Number one, if you are refused access to a residence or to an establishment, you do not break down the door, you do not call the police. We are all entitled to our Fourth Amendment protections, the protection of privacy and security of a person and a property owner. So boards of health can enter, examine, and conduct inspections, but if they are refused access, then they need to go to a court and obtain what is called an administrative search warrant. Next slide. So again, if you do find a violation, what do you do? And again, if you can ask them to stop doing it, that's great, and we're done. If they will not stop doing what they're doing, then you can either issue a civil ticket or you can issue a cease and desist order, depending upon how high the fine is. And if that doesn't work, then you can, after a hearing, suspend, revoke, or not renew a local Board of Health permit. Next slide. And if the behavior doesn't stop, you can file an application for a criminal complaint, or you can file a complaint for a preliminary injunction and go the civil action route, but I'm going to just leave you, and again, we're about compliance, not punishment. I'm going to leave you with probably my favorite slide. If you do try to enforce this through the court system, just remember, as Judge Kaufman said, the judicial system is the most expensive machine ever invented for finding out what happened and what to do about it. It's long, it's tedious, it's expensive, which is why the tobacco industry uses it as much as it does, and why we as health departments try to stay out of court if we can. That's the end of my presentation. Why don't we can take questions at the end after Mike is done, if that makes sense, or if you have any questions, I'm happy to answer them now.
Right? Okay.
Yeah, go ahead.
Let me just cycle. Then.
And actually, Jericho, I can actually pick up on my end with these.
Okay.
So,
Let her rip.
Right. Let me go into presenter view and Should not have done that so quickly. I will. All right, share to. Okay, now I'll go into presenter view. And are you seeing those now?
Mhm.
Yep.
Not the slideshow, but we're seeing the,
What do you say? Okay. Presenter view.
or play from start. Oh,
Yep,
that's
yep.
perfect.
Okay. Well, thank you, Cheryl. And by way of brief introduction, I think I know a lot of people in this room already, but I'm Mike Hugo, and I'm the Director of Strategy and Government Relations for MAHB. And I served on the Framingham Board of Health for 15 years, excuse me, and chaired it for 8 of those years through some very contentious and interesting and challenging public health issues that took place in Framingham. And I practiced law for 35 years. I no longer am in practice. I'm doing this full time. And I was doing environmental and toxic and pharmaceutical litigation when I was in practice. And I'm actually enjoying this more than anything I've ever enjoyed in my life. I have to tell you that public health is fascinating. What I want to talk to you about right now is open meeting. We're going to talk a little bit about public records, and I'm going to tell you about the new SAFE 2.0 legislation that is now law and that changes some of the things that we do and some of the ways we're doing it across the state. Again, this is the standard MAHB disclaimer. We're not giving you any legal advice here today. We're doing this strictly for education. You have a really great municipal lawyer that represent, or firm actually, that represents your town, and we're not here in their place. So let's start with the open meeting law. Essentially, open meeting law comes from the fact that democracy should be wide open. Everybody should be able to see everything that happens, how our laws and regulations are made, how decisions are made that affect people's property rights and people's health rights in this case, and people's well-being. And so in order to do that, Massachusetts legislature enacted the open meeting law, which basically gives everybody access to everything that happens in the public arena. The basics of open meeting compliance are that you have to have a notice that has to be posted properly, the agenda for the meeting. They have to be open to the public, minutes have to be kept, and there has to be a process allowing people due process if they feel aggrieved by the fact that there was a violation of the open meeting law. Those are the 4 basic. The 4 definitive questions that are asked, these are really the seminal questions. One is, if you're talking to a quorum at any time, it's very possible that you might violate the open meeting law unless you're in a meeting, a public meeting that's been opened properly. Second is if you are in communication, is what you're talking about, is that a deliberation? We're going to talk about that in a second. We're going to define what each of these are. Does the communication involve a matter within the jurisdiction of your board? And if so, does it fall within one of the exceptions listed in the law? Not everything is covered in open meeting, and we'll talk about that in a couple of slides. So basically, what is a meeting? This is the most important part, the word deliberation, because you can end up in the same place as other members of your board, and you can talk about things, but you can't deliberate anything unless you're in the open meeting environment. So the state defines it as an oral or written communication through any medium, including electronic mail, between or among a quorum of public body, on any public business within its jurisdiction. And I promise I'm not going to read my slides to you. I don't like people who read slides. You can read them yourself. And by the way, I'm going to skip through some of these slides quickly because the way that I put my slides together, I want them to be a resource for you later on. If you have a question, you can run back to the slides. We'll leave you with copies of everything we have, and you can use this later on as a some sort of a guide if you want a quick guide to go to. So as long as you're in a meeting situation that you're going to be deliberating, you're in a meeting. But there are times when you are not in a meeting when you're all together. If you're out in the field looking at a project that the board might be taking a vote on later on, you have a right to all get together and go see that. I remember we looked at a marijuana growing facility when I was on the board. We all went. We took notes. We didn't talk to each other about anything. We just took notes and listened to the tour guide. That's your best way to do it if you're out on a site visit. Attendance at a public or private gathering, sometimes you just get together. Sometimes you're on an island and you might end up at somebody's house with a quorum of your board. You may have the same common friends. As long as you are not deliberating, you don't have to say, I have to leave the room. I'm sorry because so-and-so's in the room. You don't have to do that. Just don't talk about board business. And another place which is not a meeting where you might all end up is town meeting. If you have a public health item on town meeting agenda and you want to all show up for it, you can. You don't need to notice that as a meeting because there is a specific carve out for boards attending town meeting. But basically, I think I've sort of covered that what's on this slide already with that. But just be careful that you don't deliberate. One time though, where you might get together and fall into a trap is, say the planning board has something in front of it that they're looking at, some question in town, and they want the Board of Health to get together and give do a joint presentation for the public, perhaps, or maybe they want the Board of Health to come in and consult with them on a sticky issue that might have some health implications that they may be looking at. In an instance like that, always notice your meeting with an agenda posted properly. That even though it's not technically, or you didn't think it was technically your meeting, it really is, because there's nothing more frustrating than going in front of another board and getting together with another board and having them start talking about the health implications and you not be able to speak up because you haven't posted it as a meeting. And anything you say could become a deliberation, and then you're in violation of open meeting. So if you're attending a joint meeting with another board, always post an agenda for your committee to be there, for your board to be there, and then you can sit there and give your input. You could talk back and forth and all of that. So what is a deliberation? A deliberation is a communication where you may come later on to a vote on something anything that's going to come before you for a vote. And that could also be an unresponded to expression of opinion. And that can happen in a social media environment where somebody might say something in social media and it might express an opinion. You have to be very careful, because if you know that the other members of your board are on that same social media site, it could be construed as a open meeting violation. So you could be communicating an opinion to a quorum. All right, what is not a deliberation is discussion of agendas. I know that there was well, it happens frequently that a chair of a board might want to find out whether or not everyone else on the board is available. And if your chair wants to send you an email saying, could people let me know your availability for next Thursday afternoon at 4 o'clock? That's not a violation of open meeting. That's strictly ministerial planning and basically just looking for a way to meet. That's not because you're not deliberating anything with that. You're just setting and also setting the agenda. You could have an email about, can you please put this on the agenda, or we're going to have this on the agenda, just so everybody knows in advance. Oh, and just back on the slide for 1 second. Be very careful that you don't have what's called a serial conversation. If board member 1 talks to board number 2, that's okay because you have a 5-person board. But if that second board member talks to a third member and says, board number one said such and such, and I agree, you've now violated open meeting. And that is something that can happen totally by mistake, but it is a violation. There is one exception also, though, that I should bring up, and that's called the Connolly exception. And it's where a public official, so if Rocky had something that was strictly within his purview as the health director, or if Jericho had something strictly within his purview, but he wanted to know the feeling of the board, he can actually call around and ask each of the board members, how do you feel about this? Because I'm coming up with an idea here, and I have to render a report on this for the select board. They want an answer from me, or the town manager wants an answer from me. What's your feeling about this? You can do that. And that's called the Connolly exception. It's where a public official forms a group to advise him or her on a decision that they have sole responsibility for. That group is not subject to the open meeting law. Okay, what's a public body? Well, it's a multiple member board like you are. You are actually a public body, which is why I put your picture on this slide. Figured, well, there you go, bring it home. What is not a public body in Massachusetts is the state legislature. There is, and if you read any newspapers, you know that there's a lot of movement right now among certain groups to try to get the legislature to be within the open meeting law. I don't think that that's ever going to happen in Massachusetts, but who knows? And also courts are not, the meeting of a court. This is a picture of the SJC in action. And they don't have to talk to the public about anything that they're doing for obvious reasons, because they're doing judicial decisions, and the judicial decision making process should not be open for so many obvious reasons. So there's 5 required elements in a posting. First is that you have to have the date of the meeting. Second is the time, the place, a list of topics reasonably anticipated, and the date and time of the notice posting, not the date and time of the meeting. You have that already. That's the second block there, the first and second block. But you have to have the date and time of the meeting posted on the actual posting, on the actual agenda that goes on the web page. And the list of topics reasonably anticipated. This is something that I'm going to actually recommend that maybe your chair should converse with Mr. Giorgio from KP on this particular slide. But the first couple, there's no issue about. The 48-hour rule, you have to have 48 hours exclusive of weekends and holidays prior to convening. You can post an emergency meeting as long as it's reasonable that an emergency issue has come up and you've already posted the meeting, or haven't posted the meeting, but you need to get together quickly. That can happen very frequently in a Board of Health. If you have some kind of I know that we had a mercury spill in Framingham and had no opportunity whatsoever. We found out about it at 5 o'clock in the afternoon. It happened at 3 in the afternoon. It was in a high school, and we had to have a meeting, an emergency meeting. You hold the meeting and you get it posted the next morning if the clerk's office is closed, that you had it. But the posting, the agenda that you put out there has to be visible 24/7, and some town halls have it next to the clerk's office inside on a bulletin board. And if that's the only place it's posted, that's not good enough unless town hall is always open, which they never are. So sometimes in the old days, if you remember, out in front of town hall, there used to be a posting board, and that's where the meetings were all posted. Now you do it on the internet. And that brings us to the next bullet. If your internet system crashes, and the crash lasts more than 6 hours, all meetings that are posted are now voided, and they all have to be reposted. And Cheryl and I actually were out in Great Barrington. You can't get further in Massachusetts from where you are right now than Great Barrington, and it was pretty far for us. And we got out there, and we were told as we were about to start our training out there that there had been a severed internet cable optic fiber optic or whatever it was that got severed. And it was 6 or 7 hours ago. And they had to, we went out there for nothing because they could not hold that meeting and they had to repost all of their meetings because of that. Use clear language. I've seen agendas that, item number 6, PCP about LSD, QLX. It's like, what's that all mean? No acronyms in your agenda. And this is the thing you need to talk to KP about because they have actually published a couple of papers that I've read that talk about the sufficiency of notice using placeholders. And actually, I know that there's a board that I met with last week where this is exactly what their agenda says: new business, old business, and director's report. And then at the end of it, it says we'll convene at 6. If we get done before 9, we might leave early. Is actually what was written on this agenda. Very, very folksy, but very wrong. KP does not want their clients doing anything where there are placeholders. So talk to Mr. Giorgio about that if you think that that's an issue. I've seen your agendas. Your agendas are pretty darn good, so I don't think that that's really an issue with you. But just if it ever comes to that, be aware that they have their own little feelings about this. So executive session, I've got this in 2 colors. I've got it in sort of a buff and sort of white. The ones that are in the buff colors are the ones that I think you might run into as a Board of Health. And we'll start with number 3, and I'll come back to number 1 in a second. But you could be involved in litigation, or number 7, you could have a grant that requires secrecy. Number 8, job interviews. For the first interview, you can go into executive session, and after that, it's a totally different way of interviewing. You have to have open session after that, but you can be an executive for the first round. And then to discuss certain trade secrets. I don't know whether or not on the island you have this, but in Framingham we had Genzyme. We have like 6 biotechs, all of whom have IRBs. And the laws and the rules that went with their IRBs and that go with federal contracts require somebody from the Board of Health to be on their IRB. And we could not discuss anything. We could go to their meetings and discuss go to their directors' meetings. We had to be at certain meetings where they discussed multi-billion-dollar products, and we couldn't talk about that to anybody. But let's go back to number 1. This is one where you may have this happen to you out on the island. Everybody used to think that number 1, notice to discuss reputation, character, physical condition, or mental health rather than professional competence of an individual. This used to be interpreted as if somebody is working for you and you don't think that they're working out right and they have some mental health issues, you can have an executive session on that. That's true. But this is sort of expanded for boards of health in that sometimes you have people that come before you who are having mental health crises. And immediately I think about hoarders. Hoarding is a DSM diagnosis, and hoarding is a mental illness. And if you have a hoarding case, it's just a lesson in torture for that poor person. Number 1, to hear about, from an objective mind, to hear about what their conditions are in their house. But it's also not fair to that person to expose them to public scrutiny. So if you have something where you're dealing with somebody in mental crisis, you can go into executive session for that. Special procedures for executive session. I know that you have this so well covered. I'm going to skip right through this slide because I know you know how to get into executive session. You have great leadership there that'll get you into that. This is an interesting one because we're dealing now with what happens if the public wants to come and speak. You can actually close the meeting to public comment. I think that actually it's my impression that the meeting that we're having right now I think from the announcement that was made in the beginning is closed to public comment. But you can do that. you do not have to hear from the public, but if you do, you have to allow the public the opportunity to speak without restricting what their speech is. You can only restrict the amount of time, place, and manner. Otherwise, you run into some constitutional implications. And I know that in the last meeting that I attended with you, I think Anne tried to do some quick math and tried to do some division and all of that to make sure that she didn't spend the whole night on public comment. You can do it that way. You can ask people to raise their hand if they're going to speak, and if there are 30 people that want to speak, you can give them 2 minutes. That means you're going to be there for an hour. Or if you want to give them a half an hour, you give them a minute apiece. It's however you want to do it, as long as they know going into it. Once they have the floor, once the public has the floor, you can't shut them down. You can't tell them, be quiet, stop talking, you're out of order. You can't do any of that. You have to allow them to speak for the amount of time that you're allowing anyone else to speak. And that can be a very trying thing to do as a chair. At times, you're worried about things going off the rails, and they can, but you can't step in and forbid somebody from speaking. We have slides that we do when we do the longer presentation on this. We actually show you some footage of the case that went to the SJC, including the woman's comments to a select board in Southborough, and then we show the SJC argument pieces of that when we do the larger presentation. But it's you just can't restrict what they're going to talk about, but you can tell them that their time is up after the time is up. Next is public participation on whether to you have this here. You have the slide. I don't need to go over it. But one is, though, an interesting one is to allow people to speak once, and then it's up to the chair whether or not you want to allow people to come back and speak a second time. One caveat is avoid debate. Number one on this list is avoid debate, avoid responding to any comments. You're not there to discuss whatever the issue is. This issue, if it's a public speak opportunity, usually the public is bringing something to you that they want you to know about and that they want you to act on. So if you start going back and forth with them, you're inviting disaster, actually, because you're going to end up there all night having a conversation. And some of those conversations are incredibly interesting to the board and incredibly interesting to the chair, and obviously important because somebody has come out to come to your meeting to make these points. That's important. But if it's that interesting, you add it to your next agenda or an agenda down the line. You do a little bit of research into whether or not this is something that is appropriate for the board, and this is the way the public gets to bring their issues to you. You should not be resolving any of the issues for the public that as they come and talk to you at that time. Final nuts and bolts on open meeting recordings. Any member of the public can record. It's a matter that it's their right to record, but they have to tell the chair that they're recording. They have to let people know, even though this is recorded right now, and I think you made that announcement in the beginning that we're recording it. But you can sit there in a meeting with your phone and record what's going on, but you have to notify the chair that you're doing that. The one prohibition there is you can't be obstructive with it. And Cheryl and I were in a meeting several months ago where the guy was actually putting the camera, his phone right in our faces while we were sitting there and walking around the room. And it ended up that it got so heated between the chair of that board and that particular person in the public that they ended up adjourning the meeting very early on in the meeting. That was it. The guy he was not going to allow this to happen in his meeting. And that's the right of the chair. Subcommittee meetings are open. So if you form a smaller meeting, a smaller group within, those are still open meetings for the subcommittee. If you have an open meeting complaint, go directly to your town manager and let her turn it over to town council. Accessibility, I don't think that's ever been a problem with you guys in Nantucket. I don't think you've ever had issues with that. And retain all documents seen. If somebody walks up to the table during your hearing and hands you a photograph of the piggery or the overflowing dumpster, you have to keep that photograph. You can take it and photocopy it and then give the original back, but you have to have a copy of anything that you've looked at during the meeting. And now think about that. You have to have a copy of anything you've looked at during the meeting. And we're going to talk about that right now when we talk about public records. Okay, so public records, the idea behind the public records law is that everybody has the right to any kind of access to any kind of information that you look at as a board and anything that you're considering as part of your board proceedings or during your meeting at all, for that matter. So public records are all books, papers, maps, photographs, tapes, everything, regardless of its form, characteristic, that is received or made by anybody who's a member of the board or who works for the board, any of your agents. Anything that comes through with public health, as far as you're concerned, is a public record. Every government is presumed to be public. Electronic records are treated the same. This is very important, email and text messages, because if you get a public records request and that person requesting the records wants all emails written by board member so-and-so or all records pertaining to a decision by the board to do X, Y, Z, that means all records. That means that if two members of the board send one another an email back and forth and it has to do with that topic, that has to be turned over. I don't recall whether or not you all have an at nantucket.gov or whatever your URL is. But if the town doesn't give you a town URL email account, you should set one up that has nothing but Board of Health. So it could be like, if your name was John Smith, it could be John Smith, BOH, or John Smith, Nantucket, BOH at gmail.com. You want to keep it in a separate account because if there is a request for emails from your account, your private account, it could very well be that Mr. Giorgio may ask you to put your computer into a box and ship it to Boston so they can examine your emails. And that is very intrusive, and you don't want that to happen. It could come to that, just so you're aware. So anything that you're doing as far as emails on your own email, that's all discoverable in a public records request. The same is true of your text messages. And I will tell you that there are people who are scouring the internet, looking at YouTube postings of meetings and looking to see, oh, that person just took his phone and just started texting somebody. And then the next thing you know, there's a request for, at the meeting held on such and such a date, Mr. So-and-so used his cell phone during that meeting and sent a text message. I'd like all text messages ever sent by Mr. So-and-so during the course of a Board of Health meeting. And so that then requires, again, you'll be separated from your phone for a couple of weeks while Mr. Giorgio goes through your text messages, which you don't want to have happen. So don't send texts, don't send emails, don't do anything during a meeting that could subject you to having a record requested. And if it happens, it can be extremely embarrassing. This is a text message from a mayor to her chief operating officer about the city council meeting while it was taking place. I'll give you a chance to just take that in for a second. And the blue is the chief operating officer who had just been grilled by the city council. And the mayor had to turn her phone over to the city solicitor who went through it and had to produce these. The other thing to keep in mind is that just because you produced something doesn't mean you're done producing it, because they could then come back with another request saying, I'd like to see anything since my public record request that was generated by so-and-so. And this was, I don't know which city or town this one came from, but what you see here is somebody ordering someone else to drag this record request out as long as possible and make it as confusing as you can. That's how not to get reelected if you're running for an office, just so you know. Okay, now we're going to talk about SAFE 2.0, a whole new world for local boards of health. There is a report of the Special Commission on local and I'm sorry, local and regional health. The Special Commission issued its report in 2019. Cheryl actually was one of the authors of the report and a member of the Special Commission, which was set up basically to look at local and regional public health and see what the rough spots are. Are we doing the best we can? Is it efficient? Is it fair? Is it straightforward? And the answer was that it was broken. Our public health system with 351 separate boards of health were broken, and that we needed to take some steps to improve public health in Massachusetts. So Chapter 111, Section 27D was formed shortly after the Special Commission issued its initial report. It's been amended since then, but the original intent was to encourage boards of health to be more effective and more efficient, to have a different lens of equity, and realize that there are underrepresented communities and that there are underreported health events that the boards of health are not adequately handling. And some of it was because of resources, and some of it was because of lack of understanding by the board that they had to do things, and that they didn't understand what their obligations were as board members. And one of the ways of fixing it was to increase cross-jurisdictional sharing. And the islands are one of the first 14 out of, there are now 55 shared services arrangements across the state. And the islands were one of the original participants in the cross-jurisdictional sharing, the Public Health Excellence Program, PHE program, as it's called. And that comes through this report of the Special Commission. And the Special Commission said that there needed to be improved data collection and reporting. We need some form of workforce credentialing so that we have at least minimal standards met for our workforce. Expansion of professional development, training, and technical assistance support. And on top of that now, there's a huge commitment to data, and to everything is being looked at as equity issues, that everybody has to have the same advantages as everyone else, that we should have all boards of health working on the same level, bringing the tide so that all ships are floating at the same level. There are new mandatory standards within the SAFE 2.0 legislation. Inspections, there's new standards for inspections and the data that goes with the inspections. Epidemiology, you've seen it there on the island, actually, because I know that you guys are working with Leah Hamner and with Patrick Roden Reynolds, who are both, well, Patrick is an employee of your collaborative. Leah she's a freelance contract agent, but they're working on the communicable disease issues of ticks right now, but about to expand that to a lot of other areas of epidemiology, not just ticks, for the islands, for both islands. There has to be new permitting, and the DEP and the DPH now both are working with boards of health. The DEP and the DPH have new obligations, which I'll talk about in a second. And then there has to be education, training, and credentialing. Instead of your inspectors, I know that you have a very capable inspector who I believe is on here. I don't see my screen right now because I've got the slides, but I think your inspector is here, and I'm sure he can tell you the stories of having to drive all the way to Western Mass to do his trainings for soil, which is a huge part of his day on your island. That's no longer going to be. All of the trainings that are going to be offered to your staff are going to be done in a regional basis in Barnstable County and Dukes and Nantucket County. They will come to your island to do trainings that you used to have to get on the ferry and have to go and stay overnight someplace for. That's all being changed. And then uniform data systems. I know that we worked with you with your department on getting you the new Food Code Pro, and we worked out some sort of a deal through the collaborative to get you into that electronic database, and that's just part of what the SAFE legislation is all about. And that's one of the direct benefits that your island has received from that. Your obligations are that you shall implement and comply with the standards, and the statute says individually or through cross-jurisdictional sharing. There are actually some towns, there are actually like 20 towns still in Massachusetts, cities and towns that don't belong to a collaborative, and they have to do all of this themselves. You have collaborative staff that will be doing a lot of your reporting, submitting a lot of the work, taking a lot off of the plate for Jericho and for your crew there with Rocky and his crew. Because you're part of a collaborative, but anything the collaborative is doing for you, if you were not part of it, you'd have to be doing anyway. So that's one of the benefits is that there's a little less lifting for you. There's an annual report that Rocky has to file by August 31st of this year, talking about how your department has complied with the standards. And again, I'm not going to get too deeply into that. Rocky knows this backwards and forwards, and Jericho definitely knows it backwards and forwards. And your shared services coordinators are already working on your reports for this summer through the collaborative. And then if a board is not performing, then the department will step in, and if the commissioner could actually lift state funding, public health funding from your department and restrict future funding if there's non-compliance. So there are teeth to this SAFE legislation. And in fact, I'll tell you that your delegation, at the time it was Senator Sear and Representative Fernandez, and they were champions of this legislation. They helped us so much, and we might not have been able to get this across the finish line, to be honest, without Senator Sear's help. DEP and DPH have strict obligations also under this, that they sort of used to do things, now they have to do them, which is kind of nice because now we know that we can hold their feet to the fire on certain things too, just like they'll be holding the board's feet to the fire. They have to provide the educational opportunities, and they have to provide technical assistance. That's why Cheryl and I are here. We are one of the major technical assistance providers for DPH when it comes to things like what we're doing right this very second with you. Credentialing opportunities have to be free of charge, and the funds to comply with everything are done through cross-jurisdictional sharing arrangements. Grant opportunities have to be offered by both DPH and DEP. And then there has to be basically data going through the slide. The data has to all be uniform across the state. I will say this, we'll see how it turns out, but MAHB does 4 trainings a year. We do them in the spring, and the closest one to you will be in Plymouth, and it'll be on March 21st, and that's for Board of Health members. I know last year the state was willing to pay all expenses for any Board of Health member that came. In fact, they actually paid from the grant program, they actually paid for hotel rooms for the board members. And we've asked them if they will do that again this year, and they're considering whether or not they have the budget to do it, and hopefully they do, because I know that Jericho and John and Rocky, they all have training dollars in your budget, but your budget I don't think anticipates board members actually going to get trainings. And so we're trying to get that covered for you. And what you're seeing right now is just a tiny sliver of what we do during the full trainings. Okay. Then let's move on. And I'm almost done. And then the trainings and funding obligations, basically, I think that I've covered all of that with this already. Hold on a minute, please. All right, I am done. So thank you, and I will stop sharing, and we can all see each other's beautiful faces. And Cheryl and I will entertain any questions that you have.
Questions from the board?
Very complete and very helpful. Some of it, I think we were all aware of, but some of it we certainly were not, so. It was. Any questions?
I can distribute, after I distribute the slides, if you have additional questions, I can email them over to Mike and everyone else.
Our slides, by the way, our contact information for both Cheryl and I are on the slides, and we take phone calls and emails from everybody all day long. And don't be hesitant if there's something that we can answer for you on an individual basis at any time.
I think we also have the MAHB handbook that was shown up there. We have the 2016 edition, so we can either distribute the PDFs of that, or we can print some out in the Board of Health and distribute them.
I think that would be very helpful. As both people were talking, I said, gee, I'd sort of like to have this right where I can look at it.
I think we have some 3-ring binders kicking around. I can definitely get some put together for you.
We also have, just so you know, we also have our legal guide, which is 160 something pages long, very comprehensive. Jericho, I think you may have a copy of that. But it's online, and if you're a member, which you all are, we can get you an access code, and you can go in and you can look up all of the case law and all of it needs a little updating, but anything that you're going to run into, I think, is covered in there pretty much. And we're in the process now of starting to do the updating. So I noticed Cheryl sort of smiling because that makes her happy to hear that.
Sorry, can you hear me?
Yes.
Okay. Hey, John, I'm Chief Environmental Health Officer with the town of Nantucket. Hi, Mike, Cheryl, how are you?
Good to see you, John.
You brought up horrible memory, Cheryl, with the Cambridge police thing and the cell phones and thinking of masks in cars.
Yeah. Don't do that.
Yeah, awful.
But I did want to ask a question, Mike, which you brought up regarding materials that are brought to meetings and where those are saved or stored. My impression was always those were recorded with the minutes at the town clerk's office.
If they're done right, they are, but sometimes they're not. Well, for instance, you wouldn't record plans if you had somebody come in with those massive plans, but you have them in your file cabinet.
Okay, all right. Is it fair to request all that stuff digitally?
It is. It is. But now there's also cost. You talk to your attorney about that, but there's ways of recovering costs, because those can be ultra expensive to duplicate unless you have the right plotter, which.
Oh, I see what you're saying. Okay.
Which I can give you a little hint, John. The grant bought a plotter for the group, and it's in Oak Bluff. So if you send them the digital file, they have to print it out for you and send it to you.
Oh, nice. All right.
Yeah.
Thank you.
So you know.
And I didn't mind going to Western Mass, Mike. I love Western Mass.
As long as they love coming to the island, you're okay.
And then just to draw it all together, that collaborative organization that was referenced a couple of times here with the SAFE 2.0, which I still pronounce as SAFI, is the IMA that you guys approved at the previous meeting, the intermunicipal agreement. So that is the step one. That's the renewal step for that process.
Yes.
All right, I think that brings us towards the end of our agenda, unless there's anything else from the board.
No, I
Okay.
I don't think so. I think we need a
Motion to
motion
adjourn.
to adjourn. Second,
Then a roll call.
yeah, we need a roll call. Carrie,
Yes. Yes.
Jim,
Yes.
Eric, yes, and yes,
Aye.
Tom.
All right then. Thank you very much, guys. Appreciate you coming down to give us this training, and thank you. Have a good night.
Thank you so much, everybody.
Thank you. Thank you.